new week, everyone. Uh, no chit chat, let me just go into it. So, of course, it's Monday. We're talking about employment and labor relations law, and we are borrowing from sections 2 and 40 of the Employment Act, and from the words of the Court of Appeal judges, Justices Karanja, Mumbi Ngugi, and Nyamoya, in a 2021 case. And we're talking about redundancy. Now, a person becomes redundant when they lose their job or career involuntarily through no fault of their own. And this could happen where there's a restructure of an organization so that their role in the organization becomes unnecessary, superfluous, obsolete. Just they're not needed anymore, it is genuine. Okay, but before an employee is declared redundant, there are certain conditions that an employer must comply with, and there are about 7, and we'll go through each one. Number 1, if the employee is a member of a trade union, for example, the way doctors, pharmacists, and medical practitioners have a trade union, KMPDU. If they are a member of that trade union, the employer must notify the union, and the labor officer assigned to the geographical area in which the physical location of the office is, to give them an opportunity to come and assess the reason for the redundancy and the extent of the redundancy. And that notice period should not be for a period less than a month. If the employee is not a member of a trade union, then the person to be notified is the employee in writing, and the labor officer, again within at least 30 days. And like I have said, the reason for this timeline is for there to be consultation between the parties involved. And actually, this is a requirement under the Constitution, where if administrative action is going to be taken against somebody, they need to be given written reasons for that action, so that they can have an opportunity to represent themselves. And the International Labour Organization also calls for consultation before termination by redundancy. And of course, Kenya is one of the member states to the ILO. Now, during these consultations, the employer has to be transparent and genuine. We are assuming people are operating from a point of goodwill. They have to set down criteria that assist them in this selection process of who leaves and who remains. And this is what now the trade unions will be looking at to ensure that is done fairly. Okay, it is also to ensure that parties are on the same page regarding this criteria, because you can't just wake up one day and decide you're sending some people home and you're not sending others. The criteria you used must be something that can be presented in a court of law, presented before any reasonable human being, and they will say, yes, X, Y, and Z was considered, and in deciding that person X, Y, and Z are sent away, then it's fair. We can just agree it is fair. The restructure no longer requires these people to work in this organization. Now, so those are 2 conditions that have to be met. The first one I have said, informing the trade union, and if there's no trade union, informing the employee and the labor officer. Number 3, the employer must demonstrate that in reaching the decision, they had due regard for seniority, which means the last person in is the first person out. Okay, it had regard for skill. The more skilled you are, the more you're considered to remain in the organization. It had consideration for reliability and efficiency of an employee. So therefore, there has to be this demonstration that there was a performance appraisal, and they looked at everybody's input to the organization, and that is what led them to make the decision that they did. Now, if there's the fourth condition, if there's a collective agreement between the employer and the trade union, and especially on payment of terminal benefits, then the employer must demonstrate that just because the employee is in a trade union doesn't put them at a disadvantage. They will give their terminal benefits like any other employee would. Number 5, the employer must ensure that if leave is due, then because of course now you can't be sent away for leave, you must be paid in cash in lieu of leave. Number 6, the employer must pay or undertake to pay the employee not less than 1 month's notice or 1 month's wages in lieu of notice. This is just so that the employee is able to take care of themselves, to take care of their bills. It is to cushion the employee, okay? And then lastly, the employer should be able to pay severance pay, which is at the rate of not less than 15 days for each completed year of service, okay? So those are the 7 conditions. Now, something that is just important to mention is that sometimes redundancy is driven by malice, by bias, by discrimination. You will find that somebody is sent away from an organization for being black and they are immediately replaced by a white person, for being a woman and they're immediately replaced by a man, or vice versa, okay? And that is not what a redundancy is. If you are declared redundant and then you hear that your position has been re-advertised, maybe the title has been changed, or maybe a few of your job descriptions have been removed, but it's the same job, it means they just kicked you out unfairly and you have recourse in an employment and labor relations court. Yeah, I think that marks the end of today's lesson on redundancy. Let me know if you are facing similar issues and I will advise you accordingly. Let me know if you have questions and I will advise you accordingly. Okay, thank you. Have a wonderful week.